Let's talk about data. Every single day, with every click, every swipe, every tap, we create a digital trail. But who actually controls that information? Today, we're diving into India's long, complicated, and absolutely crucial fight to answer that very question. To get started, I want you to just think about your phone for a second. Seriously, it's not just a gadget, right? It's with you all the time, but have you ever really stopped to consider just how much it knows about you? I mean, we're talking about a mind-boggling amount of information being generated constantly. It knows the exact time you wake up, it knows who you talk to the most, it knows what food you like, where you're going, what you're buying, even how many steps you take. Each little piece might seem harmless, like a single dot on a page. But here's the kicker. The real power, and honestly, the real risk, isn't in those individual dots. It's about what happens when someone connects them. When all that data is put together, it creates this incredibly detailed profile of you. And that can have huge consequences, way beyond just getting a targeted ad. So this new reality, it really set the stage for a massive legal showdown. Because for decades in India, the idea of a right to privacy wasn't actually guaranteed. To change that took a fight that went all the way to the Supreme Court. Let's just trace this journey for a second because it's pretty incredible. For more than 60 years, the legal stance was set in stone. You had cases in 1954 and again in 1964 where the Supreme Court basically said, nope, privacy is not a fundamental right. And then 2017 happened. In what's now a legendary case, the K.S. Puttaswamy judgment, the court did a complete 180, declaring that privacy is a fundamental right, essential to life and liberty, a total game changer. And listen to the language the court used. It was so powerful. Justice Chandrachud didn't just call it a legal idea. He called it an aspect of human dignity and a basic natural right. This wasn't just some dry ruling. It was a huge statement about what it means to be free in our modern digital world. And this wasn't just a philosophical victory. The Supreme Court gave a very clear order. The government now had a job to do. It needed to build a strong, robust data protection law to make this new fundamental right a reality for everyone. So, the court had spoken. Now came the hard part. How do you actually write the rulebook for data in a country of over 1 billion people? Well, you start by assembling a team of experts. In July of 2017, the government set up the Justice B.N. Sri Krishna Committee. Their mission? To tackle this issue head-on and draft the very first blueprint for India's data protection law. And to do that, they basically had to invent a whole new language to talk about data. The first key term they came up with is data principle. Now, it sounds a little technical, I know, but it's super simple. The data principle is just the person whose data we're talking about. In other words, it's you. You are the star of this show. Okay, so if you're the data principal, who's on the other side? That's what they call the data fiduciary. This is any company or government agency or really any entity that collects and uses your data. And the committee's big idea was that this relationship has to be based on trust, a fiduciary duty. It's kind of like how you trust a bank with your money. You should be able to trust these guys with your data. And finally, the committee knew that not all data is created equal, right? So they created a special category called sensitive personal data. This is the stuff that needs the highest level of protection possible. We're talking about your financial info, your health records, your biometric data, even your religious or political beliefs. So in 2018, the Sri Krishna Committee finished its work and submitted this landmark draft bill. But as you can probably guess, that was just the beginning of a whole new chapter. The government took that draft, made some pretty big changes, and then introduced it as a new bill in Parliament in 2019. And some of those changes were really debated. Take a look at the government exemptions. The original draft said, sure, you can have exemptions for national security, but they have to be fair and reasonable. The 2019 bill, though, gives the government really broad powers to exempt pretty much any of its agencies. Another big one was data storage. The requirement was loosened from all personal data to just the sensitive stuff. And critically, look at who picks the head of the Data Protection Authority. The original draft had a judge involved. The 2019 bill made it a committee of only government secretaries, which, raised a lot of questions about independence. The 2019 bill also added a couple of completely new things. It brought in rules for social media companies, saying they have to give users a way to voluntarily verify their accounts. And it gave the government the power to ask companies for huge sets of non-personal, anonymized data to help with things like urban planning. Okay, So, we've gone through all of the history, the committees, the drafts, but what does all of this actually mean for you, the data principal? This is where it gets really interesting, because this framework is designed to give power back to you. So here's the biggest takeaway from all of this. The proposed law creates a whole new set of rights for you. They're called your data principal rights. And for the very first time, they're designed to give you real, actual control over your personal information. Let's just quickly run through them. First, you get the right to access. That means you can go to any company and say, "Hey, do you have my data?" and get a copy. Second, the right to correction. If they have something wrong about you, you can make them fix it. Third, data portability. This one's cool. You can take all your data from one service, say a social media platform, and just move it over to another one. And finally, the really powerful right to be forgotten, which lets you stop companies from continuing to share your personal data. At the end of the day, building this kind of system isn't just a legal chore. It's absolutely essential. In a world where our data is literally everywhere, having strong protections isn't a luxury. It's a necessity to safeguard our fundamental rights. And so that leaves us with the ultimate question, doesn't it? As this whole thing finally takes shape, will India manage to strike the right balance? Can it protect our individual privacy without crushing the innovation that fuels the digital economy or giving the government unchecked power? The answer to that is going to define digital rights for more than 1 billion people for a long, long time to come.